हाँ सर।
హలో చెప్ All right, I request everyone to kindly maintain silence and decorum. We are now starting with the final rounds of the national level Moot Court competition 2026. Petitioner, please. You can come here. Oh, you can use that mic as audio. I believe you should speak here. Yeah, you're right.
Greeting to your honors. May it please the honorable bench, the council seeks permission. May it please the honorable bench, the council seeks permission to address the bench collectively as your lordships. Much obliged, your lordships. Your lordship, this is council. Am I visible? Am I audible now? There's an echo. Greetings to your honors. But मेरा गला थोड़ा खराब है, so I can't speak जोर से. This part? Greeting to your honors. May it please the honorable bench, the council seeks permission to address the bench collectively as your lordships. Much obliged, your lordships. Your lordship, this is counsel number 1 appearing on behalf of Ms. Alaira Veeran, the petitioner in the case of Alaira Veeran versus Lex Media Private Limited, your lordships. The council shall be dealing with the initial 2 issues, that is whether a performer's digital identity attributes and personality-based digital features be exclusively assigned to private corporation under the Indian law, and secondly, whether Alaira's creation and commercial exploitation of her independent AI-enhanced avatar amounts to infringement or dilution of Lex Media's registered trademark Alaira VTM, your lordships. For the same, counsel number 1 shall be taking 12 minutes, while my co-counsel shall be taking 11 minutes, keeping aside 2 minutes for rebuttals. Shall I proceed with issue number 1, your lordships? Much obliged, your lordships. Your lordships, issue number 1, whether a performer's digital identity attributes, including likeness, voice, signature movements, and personality-based digital features can be exclusively assigned to a private corporation under Indian law. Your lordship, in India, the law governing the commercial exploitation of private rights remain underdeveloped. Your lordship, in the absence of any statutory framework, the Indian courts have developed the concept revolving around personality rights through constitutional principles, passing off, and trademark jurisprudence, your lordship, pardon, while attempting to strike a balance between individual rights and freedom of expression. Your lordship, in the light of what has been stated by the council, it is submitted that in the present case, the performer's digital identity attributes, her likeness, voice, signature movements, the Alaira loop as it has been mentioned in the proposition, your lordship, and personality-based features can indeed be licensed but cannot be assigned. Your lordship must refer to the language of issue number 1, which states that exclusively assigned. Here we are stating that these rights can only be licensed and they cannot be assigned. Your lordships, The two terms, assignment and licensing, cannot be used interchangeably. In an assignment, the licensee becomes the owner of the interest assigned. The keyword here is ownership, your lordships. The council would like to pose this question to herself: how can one assign or make somebody else the owner of my own identity? Your lordship, this can be understood with the help of a very simple analogy. All of Taylor Swift's old music recordings are owned by somebody else, and that is agreed. A music recording is a tangible property, but can somebody own Taylor Swift as a person? Her voice, her personality, her identity? No, your lordships, because personality rights cannot be assigned and they can be only licensed. Your lordships, the council would like to refer to the case of Indian Performing Rights Society versus Eastern Indian Motion Pictures, where it was said that existing and future right of music composer and lyricist in their respective work, as defined in the act, was capable of assignment. Your lordship, if you may refer to section 2Y of the Copyright Act 1956, work has been defined. Just a second, your lordships.
Council.
It has been defined as a literary, dramatic, musical, or artistic work.
Council, with the permission of the bench, I would like to ask you, before you venture into the assignment or the licensing, I would like to know from you, like, which all rights under the IPR you are claiming?
Pardon, your lordship.
Which all rights under the IPR you are claiming, especially under the copyright? If you're saying that your voice, then the pattern in which you have the dramatic work, do you claim any kind of work or a copyrighted work which you are claiming as yours?
No, your lordship, we are just stating that the DPCA which was entered between Alaira Veeran and Lex Media Private Limited, we do agree that that particular agreement is valid. But what this DPCA is doing, if your lordship may refer to the proposition, it has been stated that when Alaira Veeran created her own AI-enhanced avatar, the corporation, Lex Media Private Limited, they sent her a cease and desist notice, which means that they are preventing Miss Alaira Veeran from using her own identity, your lordship. A distinction is to be drawn between her identity, which stems from her right to dignity, her right to privacy. If your lordship may refer to the judgment of K. Puttaswamy, there this particular stance was very well explained by your lordships of the Supreme Court. Your lordships...
So you mean to say that I'm not asking about the personality rights, I'm asking about the copyright work which you are claiming as yours.
No, your lordship.
Do you have any copyright?
No, your lordship, I'm just trying to make this point clear that the particular aspects that we are dealing with, we cannot rely on this concept of assignment. I just want to establish that DPCA is a license, not an assignment, your lordships.
Exactly.
Pardon, your lordships?
You've not challenged the contract, have you? And did you enter into an exclusive agreement or a non-exclusive agreement?
Your ladyship, it was an exclusive agreement whereby Alaira Veeran has...
This issue is based, you are saying that whether this agreement was valid contractual agreement, etc. or not. You are claiming this in a petition, correct?
Your lordship, you aren't audible, sorry.
You are claiming this, raising this issue in a petition that you have filed, correct? Under 226.
Indeed, your lordship.
Is it okay? Tell me if I am wrong. We judges are bound to make some mistakes. But without challenging this agreement, can you raise this issue at all?
Your lordship, we definitely can raise this issue because this DPCA and the conduct of Lex Media Private Limited, what they are trying to do in this particular case is they are preventing Miss Alaira Veeran to use her identity when she is trying to do by creating her own AI-enhanced avatar.
Yeah, but you agreed to all of that in the agreement, didn't you?
Indeed.
Like you gave the right yourself to the company to, to use your personality rights, and you have also commercially gained from it.
Indeed, your lordships. However, the council would like to draw a distinction that this particular agreement dealt with the personal attributes of Miss Alaira Veeran and not her identity, your lordships. Shall I continue, your lordship? Much obliged, your lordships. Your lordship, the legal rights of an individual to control the commercial or non-commercial use of their identity or personal attributes, protecting them from unauthorized exploitation of elements unequivocally associated with and identifiable with an individual, your lordships. The publicity rights with personality rights, your lordships, are that if they are one and the same, and they are also part of the right to privacy as it has been stated by the council just a moment before, your lordships, then one simply cannot assign their personality, her identity, your lordship, and it was only her personal attributes that were assigned in this particular case. We aren't against DPCA. We are against this blind straitjacket restriction that it is putting forward and is preventing Ms. Alaira Veeran from using her own identity, your lordships, because her identity is her fundamental right, your lordship, and one cannot waive away her fundamental right by signing any contract. Your lordship may refer to the case of Basheshwar Nath versus CIT. Your lordship may refer to flag number 36, page number 311 of the compendium of the respondents. It has been mentioned in paragraph number 33 that a waiver of fundamental right, which is as important as it is complex, is not possible basically in this particular case. We are saying that her identity cannot be waived off by means of any contract. So the DPCA valid, but this restriction is invalid, your lordship. And this must be addressed by your lordships in this present case, your. If your lordships have no further question, the council would like to proceed with issue number 2. Much obliged, your lordships. Your lordships, issue number 2 is whether Alaira's creation and commercial use of her independent AI-enhanced avatar amounts to infringement or dilution of Lex Media's registered trademark Alaira VTM. Your lordship, if you may refer to the Moot Court proposition, it has been mentioned in there that Alaira VTM reference is to be given to the sign of TM, your lordships. This particular trademark and Lex Media basically is alleging that there has been a violation, there has been an infringement or dilution of their trademark. But your lordship, this TM sign that has been used in the proposition and the memorial of the respondents, it itself very explicitly mentions the fact that it is still not registered. The trademark has not been granted to the respondents, and how can they claim that there has been an infringement, your lordship? Secondly, your lordship, in this particular case, what we need to focus on is that Ms. Alaira Veeran has used an AI-enhanced avatar, thereby exercising her own identity, your lordships. And in this particular case, your lordship, this particular trademark, even if we accept it without any prejudice that it is a registered trademark, your lordship, there has been no violation of the trademark Alaira V because she hasn't used any aspect of the trademark, your lordships. The only usage of the AI-enhanced model that we are talking about, if your lordship may refer to paragraph number 6 of the proposition, it has been mentioned in there explicitly that in January 2025, Alaira returned to public life and declared her upcoming independent multimedia project titled Soul of the Soil. On 14th March 2025, she released a teaser featuring an AI-enhanced avatar created by her own digital team. This avatar incorporated her likeness and so on, your lordships. So in this particular case, this usage, which was done by Alaira Veeran through her team, it is not violating the particular trademark, the Alaira VTM, which in itself is not registered in the very first place, and even if we assume so, there is no infringement, your lordship, because nothing, the word mark or anything that is related, associated with that mark has been violated or infringed by the petitioner, your lordship. Moreover, if we come on to the issue of dilution, your lordships, but before that, your lordship, the council would like to refer and bring your attention to section number 35 of the Trademarks Act, your lordships. The council would like to seek extension of time. Much obliged, Your Lordships. Your Lordship, Section 35 of the Trademarks Act 1999 expressly preserves the bona fide use of one's own name in the course of trade. Your Lordships, the Court of Appeal in Reed Executive PLC versus Reed Business Information Limited observed that additional distinguishing words sufficiently differentiated the defendant's business and that common names cannot be monopolized absolutely, Your Lordships. In this particular case, first of all, Your Lordship, the trademark, even if we assume that there was a trademark which is not there in this particular case, it was a descriptive term. And if we'll refer to Section 9 of the Trademarks Act, it refers... Shall I continue?
No, my only question is why you are assuming if you are, saying that there is no trademark. There is no trademark. Like, can you prove that?
It was just
then
an
why
argument,
should there be
Your
an
Lordships.
assumption at all?
It was just an argument, though, to counter any claim that they might.
If you have to be confident that there is or there is not.
All right, Your Lordships. So proceeding, I'll be just wrapping up my argument in 30 seconds, Your Lordships. Now coming on to the aspect of dilution, in this particular case, Your Lordship, there are three aspects that we need to consider, and if any of these three aspects are not present, first of all, there must be goodwill and reputation, Your Lordship. And in this particular case, the DPCA, which as a consequence of which Alira VTM came into existence, it has just started its journey and only 4 years have elapsed, and in absence of any evidentiary statistics that have been provided in the proposition, there are no statistics, Your Lordship. Reputation and goodwill of Alira VTM cannot be established, and hence there cannot be dilution, Your Lordships. With this, I conclude my submissions. Now I would like to invite my co-counsel to deal with the further two issues. It was an honor arguing before this bench. Much obliged.
The Council solicits permission to address the bench collectively as Your Lordships and individually as Your Ladyships and Your Lordships. Much obliged. Am I audible to the Honourable Bench? Much obliged. Your Lordships, this is Council number 2 appearing on behalf of the respondents and shall be dealing with issue number 3 and 4. If the bench has no preliminary queries, the Council seeks permission to begin with issue number 3. Much obliged. Your Lordships, issue number 3, whether the digital persona commercialization agreement, insofar as it restricts Alira's autonomy over her own likeness and artistic expression, violates her fundamental rights under the Constitution of Indoria. Your Lordships, it is very well submitted that yes, DPCA, the digital persona commercialization agreement, which I shall be referring as DPCA, due to paucity of time, yes, indeed, it violates the fundamental rights which have been guaranteed to Alira under the Indorian Constitution, which we shall be establishing upon 4 grounds. Firstly, that DPCA violates Article 21 as it extinguishes the right to dignity, identity, and decisional autonomy. Secondly, Your Lordships, DPCA constitutes an impermissible restraint on artistic expression which has been guaranteed under the Constitution of Indoria under Article 19, Clause 1, Subclause A. Thirdly, it violates the right to practice a profession under Article 19, Clause 1, Subclause G. And lastly, Your Lordships, fundamental rights cannot be contractually waived off. If the bench permits, shall I begin with the very first limb of my argument? Much obliged. Your Lordships, relying upon the landmark judgment of K.S. Puttaswamy versus Union of India, which Your Lordships may refer on flag number 28 and page number 228 of the Moot Court compendium provided by the petitioners. Are Your Lordships with me? Much obliged. The Honorable Supreme Court recognized that privacy includes personal autonomy, dignity, and preservation of individual identity. And this protection extends to the ability of a person to determine how her likeness, voice, and personality may be represented in the public domain. Your Lordships, we have not actually surrendered our right by way of this agreement. There is actually a difference between assigning differencing between assigning and licensing. In the instant case, there is just a license by which they can commercially exploit our personality. However, they cannot stop us from using our own personality, and that is the sole means for my livelihood, provided that I am an artist. It actually becomes very important for me to... Indeed. Your Lordships, Your Lordships, for issue number 3 or for issue number 4? No, I am asking your lordships. The most important judgment as asked by the honorable bench. Yes, your lordships. Indeed. Yes, your lordships. Strongest one supporting issue number 3 or issue number 4? Issue number 4 is related to the... Indeed. Oh, indeed. Indeed. Just a moment, your lordships. Indeed, we do. Indeed, your lordships. Your lordships, I'd like to highlight the case of Basheshwar Nath versus Commissioner of Income Tax, wherein the Supreme Court held that fundamental rights are not subject of waiver. Flag number 36, page number 317 of the Moot Court Compendium, your lordships. Flag number 36, page number 317, your lordships. Also, your lordships, I'd like to highlight the fact that personality rights are evolving in India. Just a second, your... Yes, your lordships. Your lordships may refer to... Paragraph. Your lordships, page number 170. Pardon, your lordships, page number 170. Yes. Your lordships, I'd also, along with this judgment, highlight the fact that personality rights are evolving in India right now, and we do not have anything very, we can take persuasive value from Indeed.
Which paragraph is relevant?
Paragraph number 33.
Paragraph number?
33, your lordships.
33, yes.
Shall I proceed, your lordships? Much obliged. Your lordships, shall I proceed with my submissions or? Much obliged. Your lordships, secondly, the next limb of my argument is that artistic and commercial self-representation through digital media is a protected expression. I'd like to highlight the case of Indian Express Newspapers versus Union of India, wherein the Supreme Court held that commercial expression is also protected under Article 19, Clause 1, Subclause G. Your lordships, moving ahead, that the restriction produces an unconstitutional chilling effect on future creativity of the petitioners. Your lordships, the chilling effect doctrine, which was evolved in Shreya Singhal versus Union of India, wherein the court held that effect of deterring individuals from exercising their expressive right is unconstitutional. And if your lordships may refer to paragraph number 3 of the Moot Court proposition, the agreement very well states that across all existing and future media formats, therefore, it actually creates a chilling effect and is uncertain, which I shall be dealing in the 4th issue as well. Further, your lordships, the council would like to highlight that DPCA violates the petitioner's right to practice any profession. Your lordships, because the right to commercially exploit one's persona is an integral to petitioner's profession. In the instant case, the exclusive assignment of her digital identity attributes prevents her from independently practicing in these platforms, which actually constitutes primary economic avenue for the petitioners. And thereby, when we are not allowed to practice our own artistic expression, our livelihood has been taken away, and therefore our source of income has also been taken away. Further, your lordships, the council is also relying upon the case of Sodan Singh versus New Delhi Municipal Committee, flag number 35, page number 304, wherein the court affirmed that Article 19(1)(g) is of the widest amplitude and covers all means of livelihood that a citizen may legitimately practice. With this, lastly, your lordships, concluding with issue number 3, fundamental rights cannot be contractually waived off. As I relied upon the case of Basheshwar Nath versus Commission of Income Tax, wherein it was held that fundamental rights are not subject of waiver. With this, the Council concludes submissions for issue number 3 and seeks your permission to begin with issue number 4.
One question. What was your commercial arrangement?
Pardon, Your Ladyship?
What was your commercial arrangement with the company? Because you are claiming that your source of income has, that is being challenged here. So what was your commercial arrangement?
Your Lordships, the commercial arrangement was that our personality attributes were exclusively licensed to the respondents. However, that does not mean the petitioner cannot actually use their own personality to earn a livelihood.
Yeah, that's okay. But has the company stopped paying you the money that was agreed on?
Pardon, Your Lordship?
The agreement was for 8 years.
Yes,
In
Your
those
Lordship.
8 years, whatever consideration was to be given to you, is that being given?
Your Lordships, the Moot proposition is silent on the same. We do not have the relevant. However, the bargaining part of the petition.
So you're blowing hot and cold.
Certainly not, Your Lordships. I'd like to highlight that the bargaining part of the petitioners in the instant case is very less, because the respondents have access to all the future technological advancements, and one cannot actually assume what all advancements can take place in the near time. If we take example of ChatGPT and AI, it was actually very different in the year 2021, and an agreement for 8 consecutive years. The technology, the AI advancement, VR, AR, everything, they can evolve at a very high and fast pace.
So that should have been considered in your agreement, no? You should be aware of this.
Your Lordships, we were aware of the fact, however...
Then did you protect your own interest? Did you put that clause into the contract?
Your Lordships, I'd like to highlight...
Why did you enter into an 8-year agreement? You should have then just entered into a 1-year or 2-year agreement.
Your Lordships, 4 years have already elapsed, and we were not having any problem. However, till the point, the respondents actually, paragraph number 7 of the Moot proposition, issued a cease and desist notice where they did not allow us to exercise our personality rights. It has been very clearly mentioned in paragraph number 7 that Lex Media issued a cease and desist notice to Alira on 16th March. And therefore, we are actually also open to, as the Honorable Court, we are actually open to the doctrine of severability as well, that certain portion of the contract can either be amended, or the portion which actually is broad and uncertain can be separated from the agreement in its entirety, as the Honorable Court may deem fit.
The suit is by them, right?
Indeed.
There is no suit by you.
Indeed.
And you just come by way of petition.
We do have a suit, Your Lordships.
You have a suit.
Yes.
For declaring this agreement.
Protection is granted, relief against you by the trial court?
The council seeks an extension of...
Any
Much obliged.
interim relief is granted by the trial court where the suit is filed by the respondent?
So, pardon, Your
Asking
Lordship.
you any interim relief granted by the trial court against you for performing whatever art you are doing. Is there any stay granted?
We have directly reached the Honorable...
If not granted, can you raise such dispute before the trial court itself? That suit may be dismissed. Why you have come to High Court?
Your Lordships, we can approach the Honorable Court because there has been a violation of public policy, firstly, which shall be dealt in issue number 4, and also there has been a violation of fundamental rights. That is a gross violation, and therefore under Article 226 of the Indorian Constitution, we have approached the Honorable Court.
Council.
Also, Your Lordships, I'd like to highlight General Clauses Act, Section 3, Clause 42, which actually allows association or body of an individual, whether in corporation or not, to approach the Honorable Court under the same.
Council, I have a doubt. When you say that you don't have you didn't had a better bargaining power, but it's been admitted that you were a renowned artist, right? And
Indeed.
you entered into an agreement, and for quite some years, even the respondent has admitted they had earned a substantial profit. So we believe that you also had the share, but you have never raised that you have not received the profits or the royalties which is out of the incurred from the agreement. So I would like to know, the AI avatar which you have created, it's a modified version. So there are many modified, the versions which you have incorporated in your avatar. So you would have spent much time and much of the financial, you would have expected much financial return. That's the reason you have come up with the new avatar. So how can you say that you were not in a better bargaining power?
Your Lordships, the facts of the proposition are silent and we are not aware of the circumstances when we actually entered into the agreement with the respondents. However, I'd like to highlight the fact that yes, we do agree that we have licensed the respondents and they shall continue to exercise the license for the next 4 years as well. However, they do not have the authority and right to actually stop us from exercising rights over our own personality, which actually stems from Article 21 as well. If the bench has no further queries, the council seeks permission to move ahead with issue number 4. I shall wrap this I just summarize it very quickly for the Honorable Court. Your Lordships, issue number 4 is whether the clause which grants respondent control over present and future technological advancements is void for overbreadth, uncertainty and conflict with public policy of the Indorian law. The Council shall be establishing the same in a twofold manner. Firstly, that the impugned clause is void for overbreadth, uncertainty and restraint of trade. And secondly, that the impugned clause is severable from the remainder of the agreement. Your Lordships, very firstly, the Council would like to highlight that under Article 29 of the Indian Contract Act, any agreement entered into between parties must be specific in terms and clearly convey the nature and scope of rights which are being transferred. The absence of definable limits creates ambiguity in understanding the contractual intent and thereby undermining enforceability, which can be, your Lordships may refer to paragraph number, Moot proposition, please. Pardon, your Lordships. Paragraph number 3, from which it can be very clearly from which it can be understood that attributes across all existing and future media formats were given. The Council seeks an extension of 1 minute to wrap up. 1 more minute, your Lordships. Yes, your Lordships. Your Lordships, the Council is also relying upon the DPDP Act, which your Lordships may refer to flag number 4 of the compendium, that such voice, biometric traits and likeness are processed only upon specific and informed consent. Furthermore, the Council is relying upon the New York Fashion Workers Act, flag number 5, where it requires prior written authorization specifying intended use. In the instant case, no such authorization intent was actually can be invoked because there is a prohibit blanket consent for all the future technological advancements. Lastly, your Lordships, the impugned clause constitutes a restraint of trade as the clause prevents the petitioner from commercially deploying the very attributes through which she practices her profession. And therefore, your Lordships, we are actually contending that the impugned clause is severable from the remainder of the agreement, which actually offending portion of the contract that is separable from the rest.
Impugned clauses of the agreement means impugned in which proceeding?
In the instant proceedings, your Lordships, that is
In a petition.
Your Lordship, as per the commercial suit, which is existing in all future media formats. This term is actually very overbroad and ambiguous, and therefore it actually gives excessive rights to the respondent. Relying upon the case of Atwood versus Lehman, flag number 52, page number 537, your Lordships, may refer to the same. And therefore, by extending control over all technological manifestations, petitioner's identity across all future formats travels beyond the legitimate scope of a commercial license. And licensing rights, even when exclusive, do not extinguish the licensor's inherent ability to utilize their own identity unless expressly and validly restricted. And there was no such restriction. Also, your Lordships, answering to the question which was posed by the Honorable Bench, commercial suit has been clubbed by the Honorable Court, which has been mentioned in paragraph number 9 of the Moot proposition. With this, the Council would like to conclude with arguments of submissions for... Yes, your Lordships. Shall I proceed ahead with the entire prayer, your Lordships? prayer, right? Wherefore, in the lights of the arguments cited, authorities presented, it is most humbly prayed that the Honorable Court may be pleased to dismiss the commercial suit filed by the respondents alleging breach of contract and infringement. Indeed, Your Lordships, and any other order that the Honorable Court may deem fit in the interest of... That is just a clerical error, Your Lordships, not a copy-paste. We humbly pray before this Honorable Court that...
Honorable High Court may pass any other order, decree or relief that the Honorable Tribunal may deem fit? High Court or Tribunal?
Your Lordships, that is a clerical error on our behalf and we are...
And
pardon.
this time is over now, we are just asking. In general, you all can consider while preparing a petition, you have to mention everything, right?
Indeed.
Under which provision you have filed this petition? What would be the prayer? So here there is no title, nothing. Where is the title in the High Court of so and so? This is the petitioner, this is the respondent. Where you have stated?
Your Lordships, that is written in the statement of jurisdiction and the cover page of the memorandum presented.
Have you, anybody has gone through the actual memo of petition filed in the High Court, any of you? So we will request the university people to provide such type of documents which are necessary to decide such type of competition, where how petition can be filed, what would be the reply, how the annexures are to be referred in the petition. So next time, it would be easy for everybody and for you to learn more.
Indeed.
How you should prepare a petition. This is out of this competition, but in future we will request whoever in charge of all this to see that the petitions, affidavit reply filed by the parties are circulated among the lawyers who are going to participate in such moot competition, or they themselves can collect from whichever source it is available. Okay.
Pardon, Your Lordships, that was as per the format of the memorandum which we were supposed to submit. It was my pleasure arguing before this honorable bench.
The Council gives its humble greetings to this honorable bench. The Council seeks permission to individually address your Lordships and your Ladyships and collectively as your Lordships. Much obliged. The Council would like to proceed with the statement of jurisdiction. Your Lordships, it is most respectfully submitted that this present...
What is the prayer in the suit?
Your Lordship, we are asking for an injunction restricting the petitioners from using the AI avatar, which was released in the teaser video for her independent project, which was Soul of the Soil.
What is the stage of hearing of that suit?
Your Lordship, it is still an ongoing procedure, but then it was stayed because
The court may ask any question, therefore. Court may ask any type of questions. You may think it is irrelevant, but then after some time you will realize that it was relevant.
Yes, Your Lordship.
At this stage you may find that it is irrelevant. Why such questions are asked? What is the stage of the suit? Are you aware or not?
Your
You
Lordship,
can give any answer because there is no such.
Your Lordship, it has been filed, but then the Honorable High Court, seeing that there were duplicity of proceedings and the parties were largely the same and the issues also were pretty coincidental, hence the Honorable High Court has clubbed the matters, and hence the matters which were filed in the lower court has been put on a stay currently.
Okay. Now you proceed.
Indeed, Your Lordship. Your Lordship, as the Council was reiterating the statement of jurisdiction, this current petition before this Honorable High Court is not maintainable because largely the dispute which is arising over here is purely of a commercial nature, which was executed between two parties who voluntarily entered into a commercial arrangement. This is largely a private dispute, and hence the petitioners should have followed the dispute resolution mechanism provided under the Digital Persona Commercialization Act. Hence, the respondent respectfully submits that the parties ought to be directed to pursue appropriate remedies under it. If your lordships are satisfied, I would like to move on to the first issue. Much obliged. Your lordships, the first issue largely deals with whether a performer's digital identity attributes, including likeness, voice, signature movements, and personality-based digital attributes, can be exclusively assigned to a private corporation under Indonesian law. It is most respectfully submitted that digital identity attributes, as mentioned earlier, constitute a valid and commercially exploitable attribute. These rights are legally capable of an exclusive assignment under Indonesian law. At the outset, it is crucial to differentiate between personal identity rights and publicity rights. Personal identity rights largely protect the reputation and dignity of a person, whereas the publicity rights protect the commercial value which is held in a person's identity. Further, the Council would like to rely on the case law of DM Entertainment versus Baby Gift House, where the Honorable Delhi High Court itself recognized the commercial value which a celebrity's persona has and deemed it a proprietary interest. It further treated this interest as a monetized substance which could be controlled and assigned. Such commercial exploitable attributes also include those which are deployed in branding, advertisements, and also inclusive of a digital avatar. And it has been consistently held that personality rights are not absolute monopolies in all contexts, but operate within the defined commercial boundaries of a contract, which is clearly seen under the Digital Persona Commercialization Agreement. The agreement was for a specific term. It had a limited scope, which was commercial exploitation, and it was a valid consideration which was payable by the respondents to the petitioners. And the ratio which I was depending on was reiterated in the case law of digital collectibles versus Cactus Funware Technology. Furthermore, the entertainment and media industries largely rely on such exclusive arrangement between celebrities and companies. It is very common for them to enter into such exclusive arrangements for endorsements, to promote their brand and goodwill to the public, and to address the commercial opportunities which arise in the market. Such arrangements routinely enable structured monetization and risk allocation. And in lieu of this, even the Supreme Court has held such arrangements as legally valid and has even recognized the legality of exploitation of commercial rights. The Council would like to also emphasize that the Digital Persona Commercialization Agreement was executed between commercially sophisticated parties for a defined consideration, duration, and courts have upheld routinely that such freely negotiated commercial arrangements are valid contracts. Concluding this issue, the Council would like to emphasize that exclusivity in such arrangements are not suspect, but an essential element. Without exclusivity, this commercial certainty, which also includes the underlying investment of the respondent, such as infrastructure for digital avatar creation and endorsements and branding, would collapse, and the entire agreement and all such agreements which imitate such arrangements would be commercially illusionary and legally untenable. If the bench is satisfied.
The question is that, you are commercially gaining from this contract. Yes. That's the reason why you are here, to protect your rights. Yes, have you tried mediation? Because 4 years have gone, 4 more years remain. So have you tried an alternative dispute resolution mechanism? You've had the arbitration clause in your contract. So before approaching the court, did you try mediation or arbitration?
Your Ladyship, in the dispute resolution mechanism, it was stated that any dispute between the parties, they would go for, of course, an alternate dispute mechanism, but it also gave the right to the respondent to move through the appropriate forum to ask for injunctive relief so that we aren't commercially exploited and we don't gain massive losses. And that is what happened in this matter, because once an AI avatar was released in the teaser, it gained a lot of commercial income, which were rights which were exclusively assigned to us. And hence, an appropriate distribution of such commercial income should have been discussed first. In no manner has the respondent ever restrained them from practicing their trade or profession. We just ask for the rights which were assigned to us to be provided.
No, injunction is fine, but also then have you tried to, discuss the off-the-court settlement and resolving this dispute?
Your Ladyship, we are very much ready to all of these options, but it is the petitioners themselves who moved to the High Court initially with this writ petition.
This is not any run-of-the-mill kind of a trade or profession. This is commercial agreement not concerning goods or sale of goods or commercial goods. This is personality rights. It's so personal to an individual. Is it not open for them to get out of it?
Your
You
Lordship,
can't tie them all life to a commercial agreement saying that because it's a commercial agreement. It's directly attributable that individual personality, distinct.
yeah, indeed, Your Lordship, but there must be a clarification that this agreement wasn't a perpetual agreement. The term is for 8 years, and seeing how already 4 years have passed, there are only 4 years remaining as such. And the only thing that we have ever been assigned are the digital attributes of her digital personality, digital persona, not her personality as a person or as an individual. The commercial interest which vests in her digital persona, that is what has been assigned under this agreement.
Any of you is aware about the proceedings filed by the celebrities in the high courts, Delhi, Mumbai, about the what type of cases are filed in the? We are reading news, right? Some celebrities are filing. What type of cases are filed? Similar type. You are artists, they are also artists, but they are filing some proceedings directly in the High Court. So whether your contention about jurisdiction, what type of cases are filed in the High Court?
Your Lordship, largely these are commercial IP suits which are filed in the High Courts, specifically the...
So how your case is different than the orders passed by various High Courts about stopping other persons to copy or something like that? Are you aware?
Your Lordship, largely those cases revolved around unauthorized use, whereas over here there has been an express authorization and consent given by the petitioner to the respondent for such commercial activities and exploitation. Hence, our matter is a bit different, though the facts may coincide, but emphasis is on the authorization part of it.
What they must have taken or raised the contention that they have special skill, so nobody should copy. But the person who is coming before the High Court, she says that she intends to use her own skill for some other platform. Can she not come to the High Court in similar type of cases?
Indeed, Your Lordship, they can. And again, we reiterate that we nowhere are restricting the petitioners from performing on any other platform. We largely ask for the commercial rights which have been assigned. That too, there is a limited scope for such. If we refer to the Moot proposition, para 3, it clearly indicates that the rights include digital identity attributes such as her name, likeliness, image, voice patterns, movements, and recognizable visual and performative features. Your Lordship, the Council seeks an extension of...
So, before we move to the personality rights, I would like to know whether the petitioner has assigned any IP rights to you?
Your Ladyship, as such, no IP rights exclusively have been assigned. We have been just assigned the attributes which have been provided under the Moot proposition. All other intellectual property rights which may arise, such as moral rights, still vest with the petitioner, and we have no claim over them. And that has never been a contention from our side as well.
Why I asked is, since she is a very veteran performer and you are using the Alira loop. It's a choreography. So whether any kind of copyrighted rights which are there of the petitioner is assigned, or is it excluded from the assignment?
Your Ladyship, the particular Alira loop that is being discussed, that has been exclusively assigned, which is clearly mentioned in para 3, which talks about signature movements and recognizable visual performative features. And it has been previously reiterated that Alira has been famous, and her Alira loop, which is a performative step, is a defining hallmark of her artistic identity, and hence that comes under the purview of a performative feature or a recognizable visual performative feature.
So do you agree that that's the original copyright work?
Yes, Your Ladyship.
So then, when the petitioner is coming up with a modified spin of the loop, so you should not have any issue with it?
Your Ladyship, we do not have any issue with it. As you can see, we have an issue with the AI avatar, not what the AI avatar functions as. It is, so if I move on to my second issue, which talks about the trademark infringement, at that point I can address these queries. And I would seek an extension of time to address your query satisfactorily. Thank you, Your Lordship. Your Lordships, it is important to note that trademark infringement arises when a sign or a commercial identifier is used in a deceptively similar manner to already a registered trademark, which causes consumer confusion. In this case, the respondent's AI avatar, which is Alira V, was developed, branded, and deployed by the petitioner's express consent. And ever since the execution of this agreement and 2022, since the deployment of such AI avatar, the respondent has consistently deployed advertisements, endorsements, and positioned itself in the market as an exclusive AI avatar associate of the petitioner. Now, the petitioner's parallel use of this independent AI in the same field disrupts an established association and has materially increased confusion amongst the consumers. The petitioner's defense, which largely relies about self-identity use and depiction, cannot be utilized because the way the petitioner has been using the AI avatar is largely for a commercial benefit which arises from her independent multimedia project. The own name and own identity defense, which is provided under Section 30 of the Trademarks Act, is limited to honest and descriptive use and does not extend to parallel commercial deployments. And because this will undermine the exclusivity which has been assigned to the respondent. Furthermore, the petitioner's conduct results in dilution of the mark Alira V. The mark has acquired sectoral distinctiveness within the digital entertainment field through the AI performance ecosystem, and dilution by blurring occurs when a single association between a distinctive mark and its source is confused amongst the consumers. The introduction of a second commercially deployed AI avatar built upon the same persona foundation fractures this exclusivity. Lastly, the petitioner's independent AI avatar deployment is not a neutral assertion of her own personal autonomy, but commercially exploitative, and that interferes with the contractual rights which are granted to the respondent under the DPCA. Such parallel commercialization undertaken without due cause takes unfair advantage and reputation of the registered trademark of the respondent. Yes.
So I would like to ask. Audible?
Yes.
In the proposition, there is a TM as a superscript. So we would like to know whether your mark is registered or is pending registration.
Your Ladyship, it is a registered trademark, hence the use of TM above Alira V as a superscript.
I would like to correct you. When TM is a superscript, it's pending. So R in a circle is which is registered, right? So secondly, like in which all classes you have sought registration?
Your Ladyship, the Council seeks ignorance of the facts about the classes of the TM.
Right. So it can be either registered under goods or both under the goods and services. And thirdly, which I would like to ask, since you had addressed the confusion which is there, I would like to know whether it is an initial interest confusion or the post-sale confusion which you are saying that because the Alera had come up with her own avatar, whether you have a confusion of which is there with the consumers initially or in the post-sale, which one you are talking about?
Your Ladyship, could we have an elaboration about the circumstance of the confusion?
Since you have, there is a deceptiveness in the mark, right? Because the petition also has come up with the Alera, the mark. And you are seeking the trademark infringement because there is a confusion in the mind of the public. Is it not? Right? So I would like to know, the confusion is something which is, which happened after the sale. The consumers are confused after buying your product, or initially itself the consumers are confused. So these are the tests which is being laid down in many of the case laws in India. So I would like to know whether the consumers are confused initially or even after they have bought the product from you.
Your Ladyship, to be precise, the AI avatar which was deployed by the respondents happened in the year of 2022. Up till 2025, we were the exclusive associate of the petitioner for her AI avatar. And then in 2025, when the petitioner released an AI avatar herself, at that moment, when that avatar was deployed in the teaser, at that point there was consumer confusion where it is very largely similar because the commercial indicator for the trademark in this manner is the persona and the features of the petitioner herself. Hence, when she releases an AI-enhanced avatar, it will, if not largely, but substantially be similar in similar in visual appearance to the AI avatar, which was as well developed and endorsed and publicized by the respondent. At that point, the consumer will have a confusion is whether the AI avatar, which is as well deployed by the petitioner, the same, or is it associated with the respondent in any manner? I would like to call upon my co-counsel to address issues 3 and 4.
The council seeks permission to proceed with issue number 3 and 4. Issue number 3, whether the digital persona commercialization agreement violates the petitioner's fundamental rights under Article 21 of the Constitution of Indoria. The respondent humbly submits, the DPCA in no way restricts the petitioner autonomy over her own likeness, voice or expression or of the like. The petitioner is merely trying to constitutionalize a purely contractual dispute. We can see in the case of ICC Development versus RV Enterprises, the court makes a clear distinction between personal identity and its proprietary commercial exploitation. At the outset, we can clearly see the DPCA is a completely valid, enforceable contract entered into by two knowledgeable parties with their own consent with consideration. This DPCA merely regulates commercial exploitation within the specified digital attributes given in the Moot proposition for a specified duration, which is 8 years. The respondent submits that the petitioner should be prevented to create a competing AI avatar, as that will disrupt the commercial stability that is in the commercial arrangement through the DCPA. The council would also like to place reliance on the case of Percept DMark versus Zahir Khan, page number 21 of the memorial. The Supreme Court recognized that exclusive commercial arrangements in the entertainment industries are legitimate tools for market regulation and investment protection. The court also acknowledged that commercial agreements involving celebrity management often contain exclusivity provisions to safeguard investments. In this present case, the respondent company has invested significant amount of time, money and resources to help the petitioner to brand her own identity, to help her gain more and more as she gets more and more popular through the DCPA
both of the petitioners and respondents will yield substantial profits, as was happening through the Moot proposition as well. We can see in point number 4, between 2022 and 2024, Alyra V, the AI avatar generated by the respondent company, featured in digital advertisements, brand collaborations, merchandising campaigns, and 3 AI-generated music videos as well. These ventures yielded substantial profits. Such an investment would be left meaningless if the petitioner would be permitted to create her own AI avatar, which would be competing for us. This would also result in a market confusion, as also submitted by my co-counsel. It would undermine the huge investment made by the respondent company for the petitioner and as well as the respondent company as well. It is submitted by the respondent that the Constitution protects identity, dignity, and freedom of expression. The petitioner has rightly exercised her practice to profess any trade or profession under Article 19, Clause 1, Clause G of the Constitution of India by monetizing her digital persona. Through the Moot proposition, she has clearly given us her commercial rights to her digital identity attributes. That tells us that she has voluntarily granted us exclusive rights, commercial rights, I would rephrase myself, commercial rights over the specified digital attributes. The petitioner now cannot go and invoke the Constitution provisions, as it is inconvenient for her at this moment. If your lordships are satisfied with issue number 3, the council will proceed to issue number 4. Issue number 4, whether the clause granting Lex Media control over all present and future technological manifestations of Alyra's identity is void for overbreadth, uncertainty, and conflict with public policy under Indorian law. As it is mentioned by my co-counsel as well, publicity rights are proprietary and commercially assignable in nature. The council would like to place reliance on the case of DM Entertainment versus Baby Gift House. Wherein the court has rightly observed the right of publicity can, in a jurisprudential sense, be located with the individual's right and autonomy to permit or not to permit the commercial exploitation of his or her likeness or some attributes of his personality. From this, we can clearly infer, in this current case, through the DPCA, the petitioner has rightly stated her own autonomy to permit to assign her commercial rights to us, as again rightly given in the Moot proposition. She has rightly exercised her freedom to trade and profess any business that she wants. The petitioner reliance on Section 27 of the Contract Act is also misplaced. Section 27 talks about agreements in restraint of trade. This DPCA merely assigns the commercial rights in the AI avatar, which was given to us through the DPCA, and it does not restrain from her carrying out any of the individual projects. The respondents have never stopped her multimedia project. We have stated that she has breached the DPCA because she has used a similar AI avatar, which is creating, as I said earlier, creating a market confusion and would undermine this huge investment made by the respondents for the petitioners. This agreement, the DPCA agreement, constitutes an assignment of proprietary interest rather than a restraint of trade. Additionally, the respondent would like to state Section 29 of the Contract Act. The clause is not void for uncertainty or being vague under Section 29. Section 29 talks about agreements for which the terms are not capable of being made certain. In the Moot proposition, we can see Point number 3, third last line, for 8 years across all existing and future media platforms, including AI, VR, AR, and synthetic simulations. The DPCA explicitly enumerates such forms of digital media platforms. The agreement was entered into by the both parties with the while they contemplated the evolving digital ecosystems. It has specifically included such media platforms, and the respondent would also like to state an example that if we buy any technology today, it would become obsolete in 1 year. This agreement was for 8 years. That time, we have contemplated this evolving digital platforms. India is developing very, very rapidly. ChatGPT was one of the very first AI. To this day, we have more than 100 AIs which can be accessed by everybody here. The phrase future technological in manifestations must be read in the light of the agreement's commercial purpose.
Counsel, I would like to ask you, in the copyright law, it is specifically mentioned if there is any agreement and the future formats are included, the artist will get a half of the royalty share. So are you willing to share the royalties with the artist?
We are willing to share the royalties with the artist as this agreement was executed between both of the parties, and till this day, we have already been sharing the profits which were generated through their AI avatar, which were created by our team.
Right. So the secondly, Alira has come up with a modified, AI enhanced avatar. So it is quite different from the avatar which you have created. And she being a very renowned artist, do you think there is a confusion in the market?
The DPCA had assigned us her digital identity attributes, including name, likeness, image, voice pattern, signature movements, and almost everything that we can see. Through that, we have created a hyper-real. Point number 4, second line, Lex Media created a hyper-real AI-generated avatar. Alira went on to create her own AI-enhanced avatar. It would be deceptively similar in the respondent's humble submission that it would definitely create a market confusion, and Alira V, which was the respondent's AI avatar, was out in the public between the years of 2022 and 2024. It had also yielded substantial profit, which means it was immensely popular within the public. Alira herself was immensely popular before she joined our company, executed a contract between us, and us also being a multinational entertainment tech enterprise, this collaboration was immensely popular within the public.
Right. Counsel, when we say deceptive similar, here also I am getting a little confused as to, regarding the trademark, what you are pressing for, whether it's the infringement of the word mark, whether it is the infringement of any of the other goods, like whether it's a logo, whether it's a word, or whether the services under the entertainment which you are claiming, that is not clear. So when you say it is deceptively similar to what?
The counsel seeks a minute to discuss with my co-counsel. The trademark has been registered by the IP registry, and we would like to protect our trademark from all fields possible so as to not create any confusion within the market. And the act of the petitioner, the counsel seeks permission for extension of time. Just 1 minute. And the act of the petitioner going on and creating a new AI avatar is meaningless, as we have already done everything in our own accord to protect this AI avatar that we have created. for the petitioner. The council seeks to move to the prayer if there are any queries to be addressed. Wherefore, in light of the issues raised, arguments advanced, and authority cited, it is most respectfully prayed that this Honorable High Court of Entity of Serenity, Republic of Andoria, may be pleased to dismiss the writ petition filed by the petitioner as being devoid of merit and not maintainable in law, declare that a digital persona commercialization agreement is valid, binding, and enforceable in law, and is neither void nor unconstitutional under the laws of Andoria, declare that the petitioner's creation and commercial use of the impugned AI-enhanced avatar amounts to infringement and dilution of the respondent's registered trademark, Alaira V, and that the respondent possesses exclusive rights over such digital and derivative manifestations of the assigned persona, direct the petitioner to pay appropriate compensation and damages to the respondent for breach of contract and trademark infringement, and pass any such further order, directions, or relief as this honorable court may deem fit in the interest of justice, equity, and good conscience, and for this act of kindness, the respondent, as in duty bound, shall forever pray.
The council seeks permission to proceed with the rebuttals. Much obliged, Your Lordship. Much obliged, Your Lordships. Your Lordships, when you have cases, you cite those cases. When you have arguments, you present your arguments. And when you don't have anything, you just keep beating around the bushes. And this is what the the opposite counsel has been doing for the past 30 minutes. Your Lordship, the counsel has 5 points to raise. First of all, Your Lordship, the counsel, the opposite counsel, is not well versed with the formalities of the court proceeding and is unaware of the facts that are the most relevant. That is related to the jurisdiction, Your Lordships. Your Lordship, they conceded to the fact that they have approached this honorable court under Article 226 of the Constitution of Andoria. Your Lordship, if their stance is to be considered, we must also consider the case of Kaushal Kishore versus State of Uttar Pradesh 2023 for SCC, Your Lordship. In this particular case, it was said that writ under Article 226 of the Andorian Constitution can only be invoked against private entities in matters of habeas corpus, Your Lordship. The second point, Your Lordship, the applicability of the ADR clause, the arbitration clause that the opposite counsel was talking about, is purely an imaginary fact that they have come up with. Third point, Your Lordship, that the respondents, the petitioner, pardon Your Lordship, acknowledge the license. 4 years have elapsed, 4 years will elapse again, but Your Lordship, we are against the embargo. And fourth point, Your Lordship, Alaira v. TM, first of all, as it was already established by the petitioner in course of her arguments, is not a registered trademark, Your Lordship. And lastly, the fifth point that the council would like to raise is that Alaira Veeran is a singer. Her identity and its exploitation is a part of her fundamental rights, and the contention that have been presented by the respondents do not stand and they do not hold any water, Your Lordship. With this, I would like to conclude with my rebuttals. Much obliged, Your Lordships.
I would like to address the points put forth by my learned opposing counsel. Firstly, when they discussed about the case law which bars us from the format of this competition allows it, that's why hence I would just like to address the points, that is it. One is the case law which was mentioned. It does provide an exception to already statutorily accepted laws, and Contractual Act, as we know, it is a statutory act. Hence, the jurisdiction part, I think I beg to differ with the respondents on this one. Lastly, it is the year of 2025. Arbitration clauses are very much relevant in the market space. In all contracts, it is now a mandate by all competent lawyers to include arbitration and an alternate dispute resolution mechanism. And lastly, about the registered trademark, it isn't an imaginary fact. It is provided under point 7 of the Moot proposition that Alaira's avatar created by her own team diluted and infringed its registered trademark. The nomenclature, as was rightly pointed out by her ladyship, is a fault, and that is all what I would like to address from the petitioner's side, and I would like to conclude my sub-report. Thank you.
With this, we come to an end to the finale round. We will shortly begin with the valedictory ceremony, requesting everyone to please be patient for this while so that we can declare the results as quickly as possible. Thank you so much, and thank you to teams for such a great performance. A huge round of applause for both the teams. Everyone, please keep your phones on silent. Respected honorable judges, dignitaries on the dais, esteemed guests, learned members of the bar, revered faculty members, distinguished participants, and my dear students, a very good afternoon to one and all. It is with immense pride and deep gratitude I, Professor Jharna Sahijwani, Assistant Professor and Faculty Coordinator of KUMCS, extend a heartfelt welcome to all of you for the valedictory ceremony of the National Level Moot Court Competition 2026 organized by Unitedworld School of Law, Karnavati University in association with the Gujarat Council on Science and Technology. This edition of the competition has truly been a celebration of advocacy and intellect. We are privileged to have witnessed 26 teams from different law schools all across the country with a distinguished panel of 35 judges throughout all the rounds from the bench as well as the bar, including eminent names such as Cyril Amarchand Mangaldas, Shardul Amarchand Mangaldas, Khaitan and Co., Khurana, and several other premier legal organizations. Over the last 2 days, this competition has showcased meticulous legal research, compelling advocacy, and spirited courtroom exchanges, reflecting on the finest traditions of legal profession. At this distinguished juncture of this program, we deem it our privilege to honor our eminent dignitaries whose gracious presence and exceptional dignity, grace, and stature has added to the charm of this ceremony itself. As a mark of deep respect and administration, we shall now proceed with the formal felicitation of our esteemed guests. We'll begin with the felicitation of our judges for the finale round. I would now request our Dean, Professor Dr. P. Lakshmi Ma'am, to kindly felicitate Dr. Annamma Samuel, DPIIT IPR Professor, Chair Professor. I would now request Dr. Charu Srivastav to kindly felicitate Ms. Komal Gupta, Chief Innovation Officer, Cyril Amarchand Mangaldas. I would now request Dr. Himanshu Sharma to kindly felicitate Mr. Bahul Shastri. Mr. Bahul Shastri is the founder of Vidigya Law Coaching Institute. I would also request Dr. Himanshu sir to kindly felicitate Mr. Harsh Gagrani, co-founder of Legal Edge and our judge for the semi-finals. I would now request Dr. Asim Chandra Paliwal to kindly felicitate Honorable Mr. Justice Biren Vaishnav, former Judge, High Court of Gujarat. I would now request Mr. Himanshu Sharma to kindly felicitate Honorable Mr. Justice A.J. Desai, former Chief Justice, High Court of Kerala. I would now request Dr. Asim Chandra Paliwal to kindly felicitate Dr. Narottam Sahu, Advisor and Secretary, GUJCOST. I would now request Dr. Charu Srivastav, Assistant Dean, UWSL, to kindly felicitate Mr. Mitul Shehlat, Senior Advocate, High Court of Gujarat. I would request our Dean Ma'am, Professor Dr. P. Lakshmi, to kindly felicitate Justice Samir Jain, Rajasthan High Court Judge. I would now request Dr. Himanshu Sharma to kindly felicitate Honorable Justice Sandeep Mehta, Judge, Supreme Court of India. To formally set the tone for this valedictory ceremony, may I now request our Dean Ma'am to kindly address this gathering and deliver the welcome address. Ma'am, please.
Good afternoon to all respected dignitaries, judges, deans, and directors of the schools of Karnavati University, faculty members, students, and participants. It's my pleasure and privilege to welcome you all to the valedictory ceremony of National Level Moot Court Competition 2026. I extend my warm and respectful welcome to Honorable Justice Sandeep Mehta, Judge of the Supreme Court of India. Sir, your presence today is a great honor for the institution and a true inspiration for our students. We are sincerely grateful to you, sir, for accepting our invitation. I especially welcome Honorable Justice Samir Jain, Judge of the Rajasthan High Court. Sir, you have always supported our institution with encouragement and goodwill. We are truly thankful for your continued guidance. I also acknowledge with deep respect the presence of Justice A.J. Desai, former Chief Justice of the Kerala High Court, and Justice Biren Vaishnav, former Judge of the Gujarat High Court, who have judged the final round of this competition. This moot court competition has been organized in collaboration with Gujarat Council on Science and Technology, GUJCOST. I would like to specially thank and warmly welcome Dr. Narottam Sahu, Advisor and Member Secretary, GUJCOST, for the constant support extended to our Center for Research on IPR. I sincerely thank GUJCOST for helping us establish the IPR cell and for providing seed money of Rs 50,000. We are truly grateful for your continued support, sir. Over the past 2 days, we have witnessed strong arguments, disciplined court conduct, and well-prepared teams. Participants from across the country took this competition seriously and gave their very best. The overall standard has been highly impressive. It is the vision of our President, Shri Ritesh Hada, to build a strong mooting culture in our law school and to properly train our students in advocacy. Thanks to him for his constant support and guidance, and this event would not have been possible without his vision and support. Thanks to Dr. Himanshu Sharma, Founding Director, Karnavati University, and Mr. Mithul Shelat, Senior Advocate, for all the support and guidance. I also express my appreciation to the senior members from nearly 20 law firms who judged the preliminary, quarterfinal, and semi-final rounds. Their involvement has added real professional value to this competition. My sincere thanks to our faculty members, organizing committee, student volunteers, and staff for the smooth conduct of this event. Dear participants, before the results are announced, I would like to say that reaching this stage itself is an achievement. Whether you win or not, the learning and experience you gained here will remain with you throughout your legal career. With this, I once again thank our honored guests for being with us today. We now look forward for the valuable words of our esteemed dignitaries. Thank you.
Thank you so much, ma'am. I would now request Dr. Narottam Sahu to to address this gathering. Sir is the advisor and the secretary to the Gujarat Council on State and Technology, a senior scientist, educator, and a visionary leader whose relentless efforts, especially for this university, has led to the culmination of this event. Sir, please.
Good afternoon to everybody. Honorable judges, chief guest, and all our respectable judges, dignitaries on the dais, Dr. Lakshmi ma'am, principal of the director of this very premium institute, all the faculty heads, our jury members, and all our bright advocates of our intellectual property rights. I think today our country is celebrating National Science Day. Science is only the quest for truth. It's a very, very fundamental right that is very unique in our constitutions also. So in our constitution there was 51H that everybody should have, every citizen should have that scientific spirit. So in that spirit, we at our department, Gujarat Council on Science and Technology, Department of Science and Technology, Government of Gujarat, we work to promote and popularize this scientific concept and clarity so that everybody, our student, our younger generations, our common citizens, they should be empowered. So we are having a year-long celebrations through our science city, our regional science centers, the district science centers, very different type of STEM institutions. So, and the intellectual property rights is one of the major thrust area. As we are moving towards Viksit Bharat through Viksit Gujarat, so it's very important to understand the IP and IPR in our day-to-day activities and practice. I think I would like to congratulate ma'am and the entire team for hosting this program and bringing these bright advocates and bright the law students, those who are going to the rule makers, the main pioneers of our judiciary systems. So once they have been groomed with these types of intellectual property issues, concern, the implications, and I think the way our country is leading, so that we have to reach our goal very soon. So we would like to congratulate all 26 bright teams, those who are participating in these premier institutions, and those who are also qualified in the final stage and taking that merit, getting that merit from our honorable chief guests and the dignitaries on the dais. And your participation and your presentation, it was not only limited to this campus and this room only. In fact, with the thanks to ma'am and with the permission, all our IP cells, we have intellectual property cells on 100+ university and institutions all across the state. And we have 28 state S&T council all across the country. So they got a glimpses of your presentation, your innovations and your ideas. And the deliberations that you have participated in the semi-final and final. I think your presentation is commendable and it has given that message that yes, we are not only the creator of intellectual property rights, we are there to protect it, fight it and get it. So this is the aims and objectives of our Viksit Bharat, and I would like to congratulate all our bright students, and I thanked the University Department of this law, Karnavati University, to giving GUJCOST as a chance, sponsor to this program. We are not like a sponsor or something, we are all working together for bringing that, building that ecosystem, and I hope that this participation, collaboration will continue, and we will be having much more and much innovative programs for students, faculties and curriculum. Thank you, ma'am.
Thank you so much, sir, for that insightful address. It is now my privilege to introduce Mr. Mitul Shelat, a senior advocate at Gujarat High Court, who is a distinguished legal professional with a strong foundation in commercial laws. Sir has developed considerable expertise in arbitration and mediation, regularly appearing in complex and high-stake matters involving established universities and schools. Beyond his courtroom practice, he serves as the chairman of Gujarat Chamber of Commerce, reflecting on his active engagement with the business and legal community. A graduate of Sir Elisha Law College, Sir leads Mitul Shelat, an associate based in Ahmedabad. Recognized for his thoughtful leadership, he has been invited at various events as keynote speakers and has contributed beyond litigation in legal education and professional development in Gujarat. Most importantly, Sir has been instrumental in shaping Karnavati University as he is the member of the governing council at our university level. We are privileged to have you, Sir, and request you to kindly address the gathering.
Honorable Justice Sandeep Mehta, Judge, Supreme Court of India. Honorable Justice Samir Jain, Judge, Rajasthan High Court. Honorable Justice A.J. Desai, former Chief Justice, Kerala High Court. Honorable Justice Biren Vaishnav, former Judge, Gujarat High Court. Mr. Sahu, Member Secretary GUJCOST, Dr. Samuel, IPR Chair Professor, Ms. Komal Gupta, Chief Innovation Officer, CAM, Dr. Lakshmi, Dean School of Law, Dr. Sharma, Founding Director, Karnavati University. Ladies and gentlemen, the topic of your moot and the topic of today's discussion evolves around two topics, if I can say. Mooting is one part and the advent of artificial intelligence is the other. As I stand here and think of the time when I enrolled as an advocate, the first thing that my senior gave me was a red book which had alphabetically indexed. And the idea was that you go to the library, read your journals, and you find citations and you write them alphabetically, topic-wise. As the profession has now evolved, I think it is a rare thing to see for a lawyer to maintain. Because now we have SCC online, Manupatra online, since last at least a decade and more. And presently now we have the advent of ChatGPT, Perplexity, all these engines which now work for us to a very great extent and enable us or empower us. So when today you are mooting, I must remind you or tell you that possibly this is one faculty which as lawyers you will have to maintain and sharpen, because with the advent of time, possibly this is the only faculty or only thing that will remain. The rest is going to be taken over by artificial intelligence, so to say, because you will have somebody thinking about the judgments which are to be cited. You will have somebody who is also going to sharpen your propositions. But it will ultimately be you who will be performing or who will be appearing before the court and articulating before the court. With the technology, you have the benefit of the courtrooms coming to the classrooms. You are in a position to see how law is actually practiced. And today, as we saw in the moot, to a great extent, a lot of the students who participated showed how that has been calibrated into their performance. When we talk of artificial intelligence and creation of identity, it comes to mind. It's an anecdote. Some say it is not actually there. But Charlie Chaplin, one of the most well-known names that people would have heard of and most recognized face, anybody in any generation would always be able to identify who Charlie Chaplin was. The word is that there were look-alike competitions. So where people would look alike, everybody who believed they'd look alike Charlie Chaplin, or they would make up and look alike Charlie Chaplin, and there would be a competition, just like Elvis Presley's competition. So Charlie Chaplin said that, why don't I also join this and see what happens? And he stood 7th. He himself stood 7th in a competition which was attributed to him. Today, with AI and the issues regarding the artificial intelligence taking over personalities, how you speak, how you perform, and I don't know, since we are all lawyers here and legal fraternity is here, when you are with AI or Perplexity, try doing one thing. You make up your case and say that, please summarize this like Mr. Harish Salve. Please summarize this like Mr. Rodgi. Please summarize this like Dr. Abhishek Manu Singhvi. And believe me, you will find the way in which these gentlemen argue in court, you will find those summaries to be there. So, what I'm trying to say here is that advent of technology is going to enable you, empower you. It is also going to take away a lot of your time, which means you'll have more time to do things to sharpen the way in which you present your facts before court, the way in which you are going to create your propositions. So it is with this that we have to accept this technology as students of law. And if we do so, I think artificial intelligence is only going to engine us into the future. So I take this opportunity to congratulate all of you to having participated in this Moot competition, which is the best hands-on thing that can happen to a student of law who desires to practice law. And I congratulate the organizers, the judges who have spared precious time, come here and judge this event. Thank you and have a good day.
Thank you so much, sir, for the address and a gentle reminder of how AI is truly shaping our lives. It is now my honor and privilege to formally introduce our esteemed guest, Honorable Justice Samir Jain, Judge of Rajasthan High Court, an eminent jurist whose professional journey is marked by exceptional expertise, intellectual depth, and unwavering commitment to the rule of law. Sir brings with him a rare and formidable academic foundation, holding qualifications in BCom, Chartered Accountancy, and LLB, a unique confluence of commerce, taxation, and law that has profoundly shaped his career at both the bar and the bench. He was enrolled as an advocate in the year 1999 and went on to build illustrious practice spanning more than 2 decades. For nearly 17 years, he served with distinction as a standing senior counsel for the Income Tax Department, representing the revenue before the Honorable Supreme Court of India, various high courts, trial courts, and arbitral tribunal. His professional expertise encompasses constitutional law, direct and indirect taxation, corporate and commercial disputes, economic offenses, and the list goes on. In recognition of his outstanding legal acumen and vast professional experience, he was elevated as a judge of the Honorable Rajasthan High Court in 2021 and is presently serving there, where he contributes significantly to strengthen tax and commercial jurisprudence. We'll just look into this. Just give us a second. We speak of technical glitches, so of course has to happen when it's on AI. We are immensely privileged and we are so sorry for the inconvenience, sir, and we would request you to kindly now address the gathering. Thank you so much.
Namaskar. Good afternoon. Honorable Justice Shri Sandeep Mehta, Judge Supreme Court of India, my mentor, my guide, and my inspiration. Upon my elevation, I sat with Sir. What I learned was punctuality, quick decision making, hard work, reading of the file, so that you are relevant in the court, you are precise, and you are apt, and you stand justified before the lawyers and the litigants who come and speak out their cases in a bountiful of litigation in a precise time. Sir, a very good afternoon and my greetings, sir. Honorable Justice Shri A.J. Desai, former Chief Justice, Kerala High Court. I have read a lot of your judgments, sir, which are precise, landmark, and inspirational. Justice Bril Vaishnav, my colleague from Gujarat High Court. Shri Dr. Narottam Sahu, Advisor and Secretary, Gujarat Scientific, what is that? Science and Technology Institute. Dr. Mitul, Senior Advocate Shri Mitul Chilak, representing in Gujarat High Court and Apex Court. Dr. Lakshmi Shanta Kumar, who is Dean of this particular institute. Dr. Himanshu Sharma, Founding Director, Karnavati University. Ladies and gentlemen, participants, and a young crowd. It is both an honor and a privilege to stand before you at this valedictory ceremony, marking the successful culmination of 2026 National Moot Court competition hosted by Karnavati University. Today, it is not merely the conclusion of a competition, it is the celebration of intellectual rigor, disciplined advocacy, institutional vision, and the indomitable spirit of young jurists who have chosen to test themselves against complexity. At the outset, I extend my heartiest congratulations to the Karnavati University by conceptualizing and executing a competition of such national stature. The institution has once again affirmed a foundational principle that legal education cannot remain confined within textbooks or lecture halls. From my college days, I've heard that law is a living discipline. It breathes in courtrooms, evolves through arguments, and matures through challenge. And now when I sit on the bench after being member of the bar for a long time, I feel an institution that understands that truth prepares not just graduates, but guardians of justice. Looking at the thematic focus of the year's Moot, intellectual property rights in the age of artificial intelligence, what a profoundly timed theme. We stand at the pivotal moment in legal history where technology is no longer a passive instrument in human hands. It is evolving into an automate collaborator. Artificial intelligence now composes music, generates art, drafts text, predicts outcomes, and even assists in judicial analytics. That raises foundational questions. Who is the author of AI-generated work? Can originality subsist in algorithmic creation? Where does liability lie when decision-making emerges from opaque computational processes? How do we balance innovation with equitable access? Long back, when there was an era of telephones, we used to remember the telephone numbers. Now it is mobile, there is a saving clause, and with each and every name, the number comes. You don't remember the names. Thereafter, thing came called calculator. We forgot the tables, and now is the AI. But in the judicial courts, definitely there is a reconciliation which is required, a balanced approach. We can take assistance for reference purposes, but human application of mind is highly required. These are not speculative inquiries of the distant future. There are present-day dilemmas confronting courts, legislators, and regulatory bodies across the globe. The same issue was also recently raised by the Honorable Apex Court. The increase of AI tools for drafting and elite works is thus an issue which is not only degrading one thinking and analytic approach towards professional and personal problems, but is also an issue for high-stake forums where the judgments given by AI tool do not exist at all on paper. Traditional intellectual property doctrines were built around human agency, yet we now navigate an era of generative agency, where machine outputs rival and at times surpass human creativity. The law must respond not with fear, but with foresight. However, regulation must not merely chase innovation. It must anticipate it, and in doing so, it must remain anchored in constitutional morality and social equity and not a robotic, rotten knowledge. The challenge before your generation is unprecedented. To ensure that technological progress strengthens justice rather than destabilizes it. I would say that moot court competitions are far more than academic exercises. They are crucibles, spaces where intellectual discipline is tested under scrutiny. In a moot courtroom, one learns quickly that advocacy is not performance, it is precision. Persuasion does not arise from volume, but from clarity. Authority does not confirm from confidence alone, but from preparation. Today, I believe you all have learned the economy of language, how to construct an argument that is sharp, structured, and responsive. You have experienced judicial interruption, the pressure of limited time, and the necessity of thinking on your feet. These experiences are formative. A real courtroom is not forgiving of ambiguity. The court's time is precious. The stakes are tangible. Client lives, liberties, reputations, and resources may depend upon the precision of your articulation. In this competition, you have rehearsed that responsibility. Most importantly, you have learned professional resilience, the ability to withstand rigorous questioning without losing composure. The equanimity will define you far more than any trophy. Moving further to the 26 teams who traveled from across this nation to participate, your very presence here is an achievement. Mooting demand sacrifice, late nights, research marathons, endless drafting revisions, and relentless practice sessions. Your victory that does not mean winning, but a victory that means fighting, expressing, speaking, and most importantly, learning, but not from the books, but from your own shortcomings and dedication. It reflects your sustained discipline and excellence. To those who may not find themselves in the podium do not mistake absence of trophy for absence of growth. The law is a long journey. The lessons learned in challenge endure longer than the applause of a moment. Allow me to leave you with the thought that legitimacy of the legal system ultimately rests not on the ink or statues, but on the moral and intellectual integrity of those who interpret and apply them. Carry with you the discipline of exhaustive preparation, the humility to engage respectfully with opposing views, the courage to defend a reasoned conviction, even when it is unpopular. The world you are entering is dynamic, contested, and complex. Courts are grappling with constitutional transformations, digital rights, environmental crisis, economic restructuring, and technological upheaval. We will practice law in an age where precedent evolves rapidly and global interconnectivity shapes domestic jurisprudence. If you preserve that core, you will not merely become successful lawyer, you will become custodians of trust. I once again extend my warmest congratulations to the university, participants, students, and all stakeholders. Thank you.
Thank you so much, Your Lordship, for that address and for inspiring us. It is now my proud privilege and honor to formally introduce our guest for this valedictory ceremony, Honorable Justice Sandeep Mehta, a sitting judge of the Honorable Supreme Court of India, whose illustrious legal journey stands as a testament to confidential fidelity, intellectual rigor, and an unwavering commitment to justice. Sir pursued his academic training in science and law, graduating with a BSc and LLB degree, and enrolled as an advocate with the Bar Council of Rajasthan. He went on to build a formidable practice before the trial courts and the Rajasthan High Court, primarily in the domains of criminal law and constitution law. His contributions to the legal profession extend beyond advocacy. He served with a distinction as a member of the Bar Council of Rajasthan, vice chairman as well as chairman, and was also entrusted with the responsibility of acting as counsel to several judicial inquiry commissions, reflecting the judiciary's deep confidence in his legal acumen and integrity. His judicial career commenced as the additional judge of Rajasthan High Court in 2011, followed by his elevation as a permanent judge in February 2013. He later served as the Chief Justice and on 9th November 2023, pursuant to the recommendation of the Supreme Court Collegium, assumed the office as a judge of the Honorable Supreme Court of India. His landmark judgments on spanning transgender rights and human dignity, evidentiary discipline in criminal trials, and protection of personal liberty and individual choice reflects a jurist deeply conscious of transformative role of constitutional courts in today's democratic society. We are deeply honored and privileged by your Lordship's presence today. May I now respectfully invite Sir to kindly address the gathering.
A very warm good afternoon to all. My esteemed brother, Justice Samir Jain, Judge Rajasthan High Court, with whom I had the privilege of sharing the bench. He is a specialized breed of judges who have done their chartered accountancy course and then joined the legal practice, specializing in commercial law and contributing significantly to this important stream of law. His judgments have been enriching the legal journals, and I appreciate what he has been doing all this time after his elevation. I too have been benefited by his visionary judgments on commercial law. Justice A.J. Desai, former Chief Justice of the Kerala High Court, Justice Biren Vaishnav, former Judge of the Gujarat High Court, Dr. Narottam Sahu, Mr. Mitul Shelat, Senior Advocate, Dr. P. Lakshmi, Dean Faculty of Dean Unitedworld School of Law, Dr. Himanshu Sharma, Founding Director, Karnavati University, distinguished faculty members, the other dignitaries present in the auditorium, participating students, and the bright young future generation of lawyers. It is indeed a pleasure and a privilege to stand amongst you to share my thoughts on this valedictory session of the Moot Court competition, which has been organized by the Karnavati University on a very important topic and a very contemporary topic in today's context, intellectual property rights and artificial intelligence. The vision of this institution, Shikshanata Siddhi, encapsulates the Karnavati University's enduring belief in the transformative power of learning, signifying journey from education to achievement. It is in this background that the topic of the Moot, in which the participating teams competed, becomes relevant. I must acknowledge that having seen the profile of the Unitedworld School of Law, the institution has emerged as a vibrant center of progressive legal education. Through its integrated programs such as BA LLB honors and BA LLB honors with specialized BBA LLB honors with specialized concentrations in IPR, business law, criminal law, and international law, as well as its doctoral offerings, the school has demonstrated a clear commitment in nurturing legal scholarship that is both intellectually robust and socially responsive. The organization of this Moot Court competition is in itself a testament to that commitment. Mooting, my friends, is not merely an academic exercise. It is an essential bridge between classroom learning and courtroom advocacy. By fostering analytical precision, ethical awareness, and the discipline of a structured argument, institutions such as Unitedworld School of Law contribute meaningfully to the development of a generation of lawyers who will serve the cause of justice with competence and integrity. As I look at this distinguished gathering, I am filled with a profound sense of confidence in the future of legal profession in this country. Before me stand young minds sharpened by knowledge, animated by intellectual curiosity, and guided by a resolute commitment to uphold the rule of law and to preserve the enduring ideals of justice that form the bedrock of our constitutional order. Moot court competitions, as we understand them today, are by no means a recent innovation. They are the product of a long and distinguished pedagogical evolution within the legal education. Internationally, eminent institutions such as Harvard University and the University of Oxford formalized structured mock trials and appellate arguments as early as in the 19th century. These institutions recognized that craft of advocacy cannot be perfected through doctrinal study alone. It must be refined through disciplined simulation of courtroom practice. In India, this tradition acquired an organized national character in year 1981 when the Bar Council of India convened the first national level moot court competition at New Delhi. That initiative marked a significant moment in the evolution of clinical legal education in our country, creating a structured platform through which the students could cultivate depth of research, precision in drafting,
and persuasive skills in oral advocacy. From that foundational step, mooting has steadily expanded across universities and states, eventually becoming an integral component of contemporary legal education. Today, many institutions conduct novice and capacity building moots. In almost all of the law colleges and universities, moot court exercises form a compulsory part of the curriculum. This reflects a conscious and a commendable effort to bridge the gap between the theoretical instructions and professional competence. As we commence this valedictory ceremony, we are reminded that mooting is not merely a competition. It is a formative discipline, one that instills intellectual rigor, ethical responsibility, and the habits of preparation that lie at the heart of effective advocacy and administration of justice. When we were students of law, this structured ecosystem had yet not taken its roots in our country. Opportunities of this kind you experience today were totally non-existent. Our exposure to advocacy was largely confined to classroom lectures, occasional debate competitions, and mandatory visits to courts, particularly the trial courts, where we observed the proceedings from the gallery rather than engaging with them as participants. The systemic simulation of courtroom advocacy, with its emphasis on memorial drafting, procedural discipline, and structured adversarial submissions, had yet to assume prominence. In that academic environment, the study of law often felt formidable, dense, with complex doctrines, extensive case law, and the constant expectation of scholarly excellence, yet far removed from the immediacy of a courtroom practice. I dare say this candidly, evening law classes of that era could scarcely be described as adequate preparation for the realities of litigation. But I was lucky. I had a heritage of legal legacy in my family. I would go to the courts with my seniors from the second year of the law education, and in that manner, by observing my seniors arguing the matters, conducting cross-examinations, and responding to the court queries, I learned to inculcate the practices which would benefit me in the future. It is this contrast, the opportunity which you have now, that underscores the significance of the moot court competitions. Whereas the earlier generations relied largely on observation and experiential absorption to bridge the divide between theory and practice, you, my dear young students, are equipped with the structured platforms that consciously integrate both. Today's moot courts replicate near-authentic courtroom environments, transforming abstract legal principles into applied advocacy skills and ensuring that academic learning translates seamlessly into professional readiness. In that evolution lies one of the most meaningful advancements in modern legal education. In my 4 decades within the justice delivery system, I have consistently observed that discipline cultivated through advocacy competitions translates seamlessly into effective legal practice. That is where you stand at a great advantage. Yet, the underlying objective of these competitions remains unchanged. That is, to refine the essential attributes of a lawyer. Mooting sharpens the capacity for rigorous legal research, demands fidelity to precedent, and compels clarity and precision in articulation. It trains the mind to identify the decisive authority, to structure submissions in a coherent and a persuasive manner, to anticipate counter-arguments, and to respond to judicial interrogation with composure and restraint. We witnessed that while sitting in the anteroom and while you were undertaking those tough questions posed by Justice Shastri and Justice Vaishnav. And I must commend you that the teams were fantastic in their response. These, my friends, are not skills acquired overnight. They are cultivated patiently through sustained engagement with exercises such as the one which you have witnessed over the past 2 days. The preparation of written memorials is also of profound significance. It instills discipline in drafting and precision in thought, reminding us that many cases are shaped as much as by the written word as by oral advocacy. Indeed, in appellate courts, especially, the clarity on paper often determines the direction of the hearing. I'll share an experience with you in this regard. My maternal grandfather was a great criminal lawyer in the state of Rajasthan. When he stopped coming to the courts, I inherited almost 2,000 files in which he had been engaged. And my friends, I'll tell you, I could prepare the arguments by merely reading the drafting of the appeals or the memorandums which had been prepared by my late grandfather, Shri M.M. Singhvi. So that is the importance of good drafting. Beyond the acquisition of skill, mooting also contributes to the formation of character. You must have experienced the teamwork fostered, the professional courtesies, and the respect for the opposing counsel. They are most important attributes of a good lawyer. The way in which a lawyer performs in the court or shows his character, shows his humility to the other side, that makes him a great lawyer, that has a great impact on the judges who are assessing the performance of a lawyer while arguing a case. It nurtures ethical integrity, the recognition that in the profession of law, how one advances an argument is just as important as the argument itself. With these reflections in mind, now let us turn to the moot court proposition that has brought all of us together on this occasion. The moot proposition placed before us engages one of the most pressing and consequential frontiers of contemporary jurisprudence, the convergence of intellectual property rights and artificial intelligence. We stand at a transformative moment in legal history. Technology is no longer merely a tool that assists human creativity. It has evolved into a system capable of generating, replicating, and commercially exploiting creative expression in its own rights. As Justice Samir Jain just now said, we have seen AI generating judgments which never exist. AI can simulate voices, replicate likeness, reproduce distinctive styles and movements, and construct digital personalities that appear indistinguishable from real individuals. In such a landscape, the foundational assumptions of intellectual property law are being tested in unprecedented ways. These developments call not for reactionary resistance, but for careful judicial reflection grounded in principles. Traditionally, intellectual property regimes were structured around identifiable authorship, originality, and human creativity. The law proceeded on the premise that every protected work could be traced to a human mind. However, AI-generated avatars, synthetic music, immersive virtual performances, and algorithmically constructed artworks challenge these core principles. When an AI system independently generates a painting or a musical composition, who is the author in the eyes of law? If a digital replica performs in a virtual environment, who owns that performance? When a person's image voice, or personality is algorithmically reproduced, what is the precise nature of the right being asserted, copyright, trademark, personality rights, or the broader constitutional protection of identity and dignity. The challenge which poses before us is that there is no comprehensive statutory framework specifically addressing the digital replicas, deepfakes, or AI-driven impersonations. Many of us have read of prominent Bollywood personalities approaching the courts seeking protection of their personality rights against unauthorized digital reproductions, deepfakes, and commercial misuse of their names, voices, or likeness. As a matter of fact, this has become a very lucrative field of legal profession. These cases illustrate that convergence of AI and IPR is no longer theoretical. It is unfolding in real time before the courts. When technologically enables the algorithmic cloning of a public figure's persona and its monetization without consent, the dispute transcends traditional copyright or trademark doctrines and enters the realm of identity, reputation, and constitutional dignity. The courtrooms thus become the arena where the technological capability collides with the jurisprudence of personality rights, compelling the courts to articulate principles capable of governing synthetic realities. The commercial replication of voices and likeness, especially through perpetual or future-oriented contractual assignments, raises serious concerns of overreach, unconscionability, and public policy. In an AI-driven ecosystem, a single consent today may enable infinite digital reproductions tomorrow. The law must therefore interrogate not only infringement by strangers, but also the validity and the scope of contractual waivers that purport to authorize indefinite algorithmic appropriation of one's identity. Can contractual freedom legitimately extend to the indefinite reproduction of a human persona, or must constitutional principles impose inherent limitations to preserve autonomy and dignity? These questions lie at the intersection of private law and constitutional morality. The challenge before the legal community, therefore, is not to resist technological progress, but to ensure that it operates within a coherent and a principled legal framework. The path forward may not require entirely new legal regimes. It may instead call for a thoughtful refinement of existing doctrines. Legislatures may consider clarifying authorship provisions for AI-assisted works by introducing transparency or disclosure obligations for synthetic content and exploring statutory recognition of digital personality rights. Courts, guided by constitutional values of fairness, autonomy, and human dignity, will inevitably play a central role in shaping reasoned responses to these emerging disputes. This moot competition, therefore, has been far more than an academic exercise. It has engaged you with questions that courts across jurisdictions are already beginning to confront. In addressing the proposition, you are called upon not merely to interpret statutory propositions, but to examine the philosophical foundations that underlie them. You are called upon to reconcile innovation with accountability and commercial freedom with constitutional restraint. The learned judges have now had the opportunity to evaluate your written memorials and oral submissions. And so, in doing so, they must have assessed not only your eloquence, but the depth of your research, the clarity of your reasoning, your ability to respond to sustained judicial questioning, and the discipline with which your arguments were structured. Equally important must have been the civility, the composure, and the professional integrity with which you conducted yourself, the qualities that distinguish not only effective mooters, but responsible officers of the courts. As you conclude this competition, I would urge you to reflect on the larger significance of the issues that you have debated. The questions raised here will not remain confined to the halls of this moot court. They will shape litigation strategies, inform legislative policy, and influence judicial reasoning in the times to come. The responsibility will rest with your generation of lawyers to ensure that as artificial intelligence advances, the law continues to safeguard what is fundamentally human: creativity, identity, autonomy, and dignity. Technological changes may be inevitable, but the preservation of constitutional values is a conscious choice, one that legal profession must renew with every generation. To all the participants who are gathered here today, I would say this as a word of advice. Embrace every moment of this journey. Learn not only from your success, but equally from your setbacks, for it is often in the challenge that true growth occurs. When a judge interrupts you with a probing question, receive it with quiet appreciation, as it signifies engagement and prepares you for the rigors of real courtrooms. Judicial interrogation, my friends, is not an obstacle. It is an invitation to think more deeply, to refine your reasoning, and to evaluate your submissions to the standard that justice demands. Even your opponents, in exposing the vulnerabilities of your case, render you a professional service by strengthening your analytical discipline and sharpening your advocacy for the future. The resilience, the intellectual rigor, and the ethical grounding which you have cultivated in this competition will matter far beyond the confines of this exercise. The skills you refine today will one day defend rights, protect liberty, and uphold the rule of law. While one team may ultimately receive the trophy, the true accomplishment belongs to every participant who undertook this demanding process of preparation, reflection, and refinement. The confidence forged under scrutiny, the clarity developed through structured arguments, and the composure sustained under pressure will endure far longer than any medal or a certificate or a trophy. It is this enduring professional imprint that distinguishes those who have been shaped by advocacy forums and accompanies them throughout their journey at the bar, and for some, perhaps even to the bench. At the same time, permit me to offer a measured word of caution. Moot court competitions are invaluable in shaping discipline, sharpening advocacy, and instilling courtroom confidence. Yet, they are but the thresholds of legal profession, not its culmination. Success in simulated forums, though commendable, must not foster the illusion of mastery. Real courtrooms are fluid, demanding, and often unforgiving. They require the management of anxious clients, the navigation of procedural complexities, the agility to respond to unforeseen developments, and the composure to act with restraint when the stakes are real and immediate. The practice of law demands not only intellectual skill, but humility in learning, patience in process, and maturity in judgment. Regard your moot experiences, therefore, as a foundation strong and essential but never as a substitute for sustained effort and ethical depth. The law is a living instrument continually evolving with the needs of society. As future custodians of this profession, you must be prepared not only to interpret the law as it stands, but to shape it in accordance with justice and constitutional conscience. This profession, my friends, is profoundly fulfilling. It engages the intellect, tests character, and offers the rare privilege of serving society in moments of consequence. Let your guiding principles be this: to let service give meaning to your success, to let service give meaning to your success, and not success become the sole measure of your service. For the advocacy you cultivate today will one day carry the weight of another's hope, the protection of another's liberty, and the preservation of the rule of law itself. As I conclude my remarks, permit me to share a perspective from the bench. When I witness a well-prepared advocate advance a cogent submission, respond with deliberation to judicial queries, and maintain the highest standards of professional decorum, I am reminded of the solemn responsibility that rests upon those entrusted with the administration of justice. Every order pronounced, every precedent laid down does not remain confined to the pages of a law report. It shapes life, molds legal principles, and sustains public confidence in the justice delivery system. It is this weight of responsibility that gives enduring significance to the discipline, intellectual rigor, and the ethical grounding you cultivate today. The habits of preparation, the clarity of reasoning, and the integrity of conduct you develop in forums such as these will one day inform arguments that define rights, influence jurisprudence, and strengthen the rule of law. What may appear today as an academic exercise is in truth preparation for stewardship in a system where words carry consequence and advocacy carries impact. It is in that spirit that I look upon you as future bearers of this solemn responsibility. As you move forward, approach such forums not merely with the desire to prevail, but the commitment to learn. Argue with conviction, yet listen with respect. Compete with intensity, yet conduct yourself with honor and dignity. I extend to each one of you my sincere good wishes, not only for the outcome of this competition, but for the journey that lies ahead. May you, in every role you assume, uphold the majesty of law, preserve the dignity of justice, and contribute meaningfully to the continued strengthening of our legal system. May you rise to the occasion. May you serve the last man standing. It has indeed been a pleasure to be present amongst the young, bright future of this country's legal fora, and to witness the culmination of what has clearly been an enriching and intellectually rigorous exercise. I extend my warmest felicitations to all the participants. I convey my sincere appreciation to the esteemed faculty members and the organizers whose vision and dedication have nurtured the vibrant culture of academic rigor and professional excellence. Through platforms such as this, you are doing far more than preparing students to obtain degrees. You are shaping advocates defined by competence in skill, strength in character, and the fidelity to conscience, the qualities that will sustain both the profession and the justice system it serves. My sincere gratitude to Professor Lakshmi and the founders of this institution for having invited me in this vibrant discussion. Thank you. Jai Hind.
Thank you so much, Your Lordship, for your enlightening address and your words of wisdom. It was truly inspiring. As all the dignitaries have correctly mentioned, this competition was a culmination of efforts of a lot of individuals and organizations. A special appreciation to Mr. Gadvi, who's the member of the District Legal Services Authority. Thank you, sir, for your presence. Without further ado, we move to the most awaited moment of this afternoon, the distribution of awards, which will reflect on your advocacy, your skills, and courtroom performance. So I have the awards with me, and we'll now begin with the prize distribution ceremony. All right, so the award for the second best memorial is conferred upon NMCC 16 GLS University. A huge round of applause, everyone. Now the award for the best memorial for this competition has been awarded to NMCC 2 Institute of Law, Nirma University. Many congratulations. The award for the second best speaker goes to NMCC 16, Ms. Suchi Tyagi, DNLU, Jabalpur. The prestigious award for the best speaker is conferred on Speaker 1 from NMCC 2, Ms. Katyayani Rana from Institute of Law, Nirma University. Ms. Suchi Tyagi, second best speaker. Ms. Katyayani Rana, the best speaker. The award for the second runners-up team goes to NMCC 2 Institute of Law, Nirma University. Many congratulations. A huge round of applause. The award for the runners-up is presented to NMCC 13, Guru Gobind Singh Indraprastha University, New Delhi. Many, many congratulations. And the winner of the national level Moot Court competition 2026 goes to NMCC 12 DES Navalmal Firodia Law College, Pune. Many congratulations to the team who are the winners of this competition. A huge round of applause. We extend our heartiest congratulations to all the teams, and we would now request all our dignitaries to kindly proceed for the group photograph. To formally conclude this valedictory ceremony, may I now request Dr. Himanshu Sharma, Founding Director of Karnavati University and a pillar of this organization and a huge supporter of UWSL, to kindly deliver the formal vote of thanks.
Thank you, Charna ma'am. A very good afternoon to all the dignitaries here, all the students. On behalf of Unitedworld School of Law, Karnavati University, it is my privilege to propose the vote of thanks for this momentous valedictory ceremony of the national level Moot Court competition 2026. We are deeply honored by the gracious presence of all the dignitaries on stage and off stage. All lordships, your presence has elevated this occasion beyond celebrations into inspiration for us. Your insightful words and encouragement will resonate with every aspiring advocate present here. I extend my sincere gratitude to all the respected faculty members sitting here right in front, judges of all the preliminary and advanced rounds, and the organizing committee whose dedication and meticulous effort ensured the seamless conduction of this event. To all the participating teams from all across the country, we have had teams from all across the country. Your research, advocacy, and courtroom decorum reflects the true spirit of mooting. You are not merely competitors, you are the future custodians of justice. I also thank our students, volunteers, our technical support team, our sponsors and support staff, the silent pillars behind this successful event. As we conclude, we carry forward not just trophies and certificates, students, but sharpened intellects, refined arguments, and renewed commitment to the rule of law. Thank you all for making this event a grand success.
Thank you so much, sir. we will now proceed with the conclusion. I would request all the participants to kindly stay back to collect your certificates, and I request the August gathering to kindly rise for the national anthem.
गणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We conclude the national level Moot Court competition 2026. Thank you everyone for your presence. Thank you judges. Participants, kindly please stay back to collect your certificates. Just give us a few minutes.